This is the 29th day of August 2019. Court number being used is court 15. Appearances are as follows. Presiding officer is Magistrate N.M. Carrican. For the complainant is the South African Human Rights Commission, duly represented by Advocate B. Jones. The respondent is Adam Catzavelos, represented by Mr. L. Shane. Equality Court clerk that's also present is Mr. R. Ramalaka. For the purposes of housekeeping, a written request was made to the court to broadcast the proceedings. This was canvassed with the applicant, who had no objection, while the respondent left the decision to the discretion of the court. The court had noted the huge public interest that this matter enjoyed. The court concluded that in line with the principle of open justice, it would be in the interest of justice to allow the proceedings be broadcast. This was communicated to the media houses present with a proviso that there be no flash photography. Ordinarily, this court would have had to consider and decide as to whether this matter is justiciable in the Equality Court before formally having the matter set down. This was not done in this case. The matter was simply enrolled upon the complaint being lodged. This court is, however, satisfied that the Equality Court is correctly seized with the matter. This issue was canvassed with both legal representatives. Both parties have agreed that we may proceed in this fashion. Are the parties ready to proceed?
Yes, Your Worship.
Thank you. Advocate Jones, what's the position?
Thank you, Your Worship. I would like to confirm that the parties in this matter have reached a settlement, and I would therefore like to read the settlement agreement into record.
Is that correct, sir?
I do confirm that is correct, Your Worship.
May I proceed, Advocate Jones?
Thank you, Your Worship. In May 2019, the applicant instituted proceedings in terms of Section 20 of the Promotion of Equality and Prevention of Unfair Discrimination Act 4 of 2000, the Equality Act, against the respondent for the use of the word kafir in a video that subsequently went viral. The basis of the application was that the respondent had communicated hate speech as defined in Section 10, subsection 1 of the Equality Act by his use of the word kafir in a self-recorded video in August 2018. The parties were desirous of settling the matter on an amicable basis, and the legal representatives for the respondent availed themselves for a meeting with the applicant on 26 August 2019, on which day the parties agreed to the terms and conditions set out herein. The applicant accepts the facts as set out in the respondent's answering affidavit. The following are the principal terms of argument. The respondent agrees that the respondent agrees that the use of the racial epithet kafir in a self-recorded video in 2018 constitute hate speech as defined in Section 10, subsection 1A of the Promotion of Equality and Prevention of Unfair Discrimination Act 4 of 2000. The respondent shall issue an unconditional public apology to all South Africans on the date of the court order, which apology shall be published in full on the applicant's website and social media platforms and communicated by the respondent to South African media houses at the Randburg Magistrates Court on the 29th of August 2019. The respondent shall provide the applicant with a draft of the apology for pre-approval before the apology is published. The respondent agrees to pay damages in the amount of 150,000 rand to a charitable organization that promotes social cohesion non-racialism, social justice and reconciliation in Soweto, which organization shall be the Seth Mazibuko Legacy Foundation. Registration number 2010/022059/08. The 150,000 rents will be paid in monthly installments of 5,000 over a period of 30 months. Payment will be made on or before the seventh day of every month, commencing on 7th September 2019. Payment will be made into the bank account details of the Seth Mazibuko Legacy Foundation. The respondent will perform 160 hours of community service under the auspices of the Seth Mazibuko Legacy Foundation for a period of 6 months. This agreement shall be made an order of court. This is our humble plea to this honorable court. And accordingly, the respondent accepts and agrees to be bound by the terms of this agreement as made an order of court in terms of the draft order that was submitted. This agreement constitutes the entire agreement between the parties, and any provisions not contained herein shall not be of any force or effect between the parties. No variation, modification, or waiver of any provision of this agreement or consent to any departure from this agreement shall be of any force or effect unless reduced to writing or signed by the parties. No failure, delay, relaxation, or indulgence by any party in exercising any power or right conferred on such party in terms of this agreement shall operate as a waiver of such right, nor shall any single or partial exercise of any such power or right preclude any other or further exercises of that power or right in terms of the agreement. No party may cede any of its rights or delegate or assign any of its obligations in terms of this agreement without the prior written consent of the other party. This agreement, Your Worship, was signed today by myself on behalf of the South African Human Rights Commission and by the respondent, Mr. Adam Catzavelos. As the court pleases, Your Worship.
Thank you. Mr. Shane?
I confirm whatever my learned friend has said. Thank you, sir.
In respect of the beneficiary Seth Mazibuko Legacy Foundation, have you satisfied yourself to its identity?
We have, Your Worship, and we are satisfied. My learned friend has given a full exposition of this organization, and we are satisfied with it.
Thank you. On the issue of cost, this is an equality court matter. I take it that the parties have agreed that no cost should be ordered.
That is confirmed.
That is correct, Your Worship.
Thank you for that. The settlement agreement is marked Exhibit A. It will form part of the record. Having heard the parties and considered the matter, the court is satisfied that the parties adequately applied their minds to the settlement agreement. The settlement agreement was handed to the court prior to this court starting, so the court had the benefit of at least going through the settlement agreement. The court is further satisfied that the interests of society, the complainant, and the respondent were adequately considered and balanced in reaching the settlement. In the circumstances, the court accepts the settlement agreement and it is made an order of court. No costs are ordered.
As you please, Your Worship.
Thank you. That concludes this matter. Court adjourns.
So Mr. Catzavelos will reach out to his public apology.